you pointed me out to the fact that sometimes anti-SLAPP motions can be brought by public agencies against writ petitioners. And you pointed me to the Vargas versus City of Salinas case, which I had not read before. It was really interesting. That when a citizen complains about something the government is doing, the government can procedurally attack the complaint as an abridgment of the government's First Amendment rights. And I wanted to ask, does it make sense to you that the government is a person protected by the First Amendment within the meaning of the anti-SLAPP law?
Well, the California Supreme Court has said so, but I think it makes no sense. The First Amendment was designed as a limitation on the government's ability to restrict the speech of individuals, particularly individuals who complain about the government activity, and to protect petitioning activity by individuals against the government. And I've seen cases where I've brought petitions against public agencies, and they've responded with anti-SLAPP motions, which, as you both know, are very powerful tools, and oftentimes quite righteous, but can really make it hard for a petitioner to ever see their day in court, at least in a timely way, because they bring the proceedings to a halt. By and large, they're subject to immediate appeal, whether you win or lose the motion. And the fact that public agencies in California, the California Supreme Court has said, can bring anti-SLAPP motions against people trying to petition the government for the redress of a grievance makes absolutely no sense to me.
I tend to agree, unless it's the pure case where the lawsuit is filed as a result of a public official's speech and an individual public official sued. That might be the case where, you have a righteous anti-SLAPP motion, but I tend to agree, because there is the potential for a chilling effect on people's willingness to even risk an anti-SLAPP attorney's fee award by filing a simple writ petition.
Yeah, it seems to be one of those situations where the distinction matters, where they say, individuals have rights, governments have powers. Right? Government doesn't have a First Amendment right. Government just wields the big stick. Doesn't get to use the Constitution against the people. That's an interesting case. Peter, do you know, has there been any movement in that doctrine? This case that Jeff mentioned, Vargas versus City of Salinas, was back in 2009. So that's 13 years ago. You notice that, is there any trend on that, or any decisions following that one way or the other?
There was a more recent decision. Oh boy, and I've got this makes for bad radio, but there was a more recent decision by the California Supreme Court that I believe it was a labor dispute involving a university, where the petition was really attacking the actual decision of the university, and not any speech. And the California Supreme Court said, look, a public decision is not speech protected by the anti-SLAPP statute. And that struck me as correct.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.